Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everybody. Happy to have you back with us on this simulcast for the Bottled Business Sense show. This bright Tuesday morning, we're going to speak to you about a very interesting topic that Rick and I kind of coordinated together, if you will. I'm Bill Bernard, and I'm here with my co-host, Rick Moscoso. Good morning, Rick.
Good morning, Bill. How are you?
Doing fine, and looking forward to talking about this interesting topic that I think pans or scopes over the marketing and legal issues that a lot of our business entrepreneurs are involved in on a day-to-day basis. We're going to talk about what we feel to be the 10 most important legal issues that relate to social media, which of course involves video marketing to a large extent.
Yeah, absolutely. I mean, this is a big one. This is a big one because more and more, if you're not on social media as a business owner, you need to be, otherwise you're missing out. I mean, if we take a look at some of the recent stats about social media, and really the two most popular business platforms that people use out there are Facebook and Twitter. Facebook, obviously, since it was out first, but there's over 1.2 billion registered users on the Facebook platform, and really only about 650 million are actively using it.
Only.
I mean, the numbers are staggering.
They're staggering, and you know, I know LinkedIn isn't the typical social media site, but of course it's used to a large extent by a lot of business people, a lot of our listeners and viewers, and certainly used by me quite a bit. And I know there are issues that involve an overlap of conducting a business and being social on the World Wide Web today that could cause certain business legal issues to arise that could present potential pitfalls. And the first one that normally comes to mind to me is when you have a employer-employee relationship, and the employee is on Twitter, Facebook, LinkedIn, or blogging, or in chat rooms, or whatever, and they're potentially disclosing confidential information or trade secrets. And of course, as we all know, or we should know, trade secrets that consist of information that is very difficult to acquire independently. It's information that can't be duplicated individually by someone. They have to get it from the files and from the company inside the company doors, so to speak. They have to extract it from the company. And if they start using this information and start putting it out there on social media, they could run into some problems by disclosing this.
Well, I could see where just an inadvertent mention or non-mention, but an insinuation of something that's actually confidential can create a chaos storm, right? Sure. So employees may not even know they're doing it. And it could just be something shared to their friends, and boy.
And that's why, Rick, you have to make sure you have policies in place that make it known to the employees. And in an employee manual, the ones that I do for my clients, you do have issues involving disclosure of trade secrets and privileged information or proprietary information. And of course that puts the employee on notice of what he's doing. So he can't claim, well, I didn't know better, if he's got a manual that he signed off on that says he should know better, whether he reads the manual or not, he signed off on it and he's unnoticed.
Yeah, I know some of the bigger businesses either block these social media platforms from work or don't allow you to use it.
Right.
So to really prevent some of this stuff happening, although they can't really control what happens at home, but the onus is on the employee then.
Sure, absolutely. You're absolutely right, and leads us into the second issue that we run into a lot, and that's use of trademarks. You have to make sure you're not impermissibly creating a false impression of endorsement or affiliation or sponsorship or some sort of an agreement whereby you are professing to use a trademark that somebody else has trademarked, and you're out there using it because it's popular, it looks good, or just because you think it'll be okay to do. You have to be very, very careful on websites and social media and blog sites, chat rooms, you name it. You got to be careful of that. And I'm sure as a marketing person, when you're doing your videos and media marketing for your clients, that you make them aware of that as a natural progression.
Well, absolutely, and it's probably one of the most violated things when it comes to the visual arts because it's so available to the average person or to the amateur that even something as little as putting a soundtrack, somebody on a simple video, is a copyright infringement. Right?
Have you ever made copyright and also trademarks? Have you ever seen a trademark, Rick, that actually used as part of the trademark logo somebody's picture?
Somebody's picture, an individual's picture?
Yeah.
Nothing comes to mind.
Well, certainly you could do that.
Yeah.
But let's look at a trademark separate and apart from a picture that's part of a logo. I have a client who wrote a couple of books, and he was a very young man, actually a young teenager, just coming into manhood now, and he was very, very concerned about getting the proper endorsements on this book, and so he called the offices of Donald Trump in New York on a consistent basis, over and over and over. He finally got through to Mr. Trump, got to meet him in New York City, and Mr. Trump took a picture with him endorsing his book with a photograph of him next to Trump. And there was a contract put in place that he could only use that for a certain period of time. Mm-hmm. Now he's got the endorsement and the permission of Donald Trump to use that photograph, and he can post it wherever he wants on his social media sites or wherever. Once that contract expires, we know what will happen if he tries to do that.
Right.
Okay, so you have to make sure that whether you're talking about trademarks, copyrights, patents, you have to, well, patents not so much because they're going to be patented for a certain period of time. No one's going to give you permission. The copyrights and trademarks, you get somebody's permission before you start sticking them up everywhere, because while it may promote your business, or at least you may think it does, you could run a terrible risk of getting sued.
Well, I think we've seen this happen just recently in the news with Dr. Oz. Right. You know, he may mention a certain ingredient in a product, not specifically a product, but an ingredient in a product, and then these, product vendors will take that ingredient and say that he's promoting our product because it has this in it, right? And I know he's been on the rampage about finding these people and shutting them down.
Well, there's an interesting little tidbit that I want to add on to that when we come to the end of our near the end of our show, involving securities, and how security, the need to be careful of the violation of the securities laws, can also play into this social media situation. But continuing on in our discussion, the third item we spoke about was copyright protected works. That creates a real problem. If somebody's got some information, videos, music, photographs, anything like that that is copyrighted, you need to make sure you ask for their permission before you start using it.
No, absolutely.
And I know there's source codes out there, some of which are copyrighted and some which aren't. And there are some source codes that you can just use without getting someone's permission, but I would always caution somebody to make sure and call anyway, get that permission. And I don't know how much you get involved with source codes in your marketing business, but my guess is that's better left to some IT guy who really is really attuned to that.
Yeah, absolutely. I mean, really, our standard practice in the studio is if we're applying music beds to certain videos,
Right.
and no matter what we do, we always use royalty-free music. So,
Right.
and we pay for that subscription, so we don't run into any of these problems.
That's fantastic. Where can people find that, Rick? Where's that website?
Oh, there's a number of different sources out there. Musicbed.com is one of them.
Okay.
There's another one. We use videoblocks.com.
Okay.
If you just Google royalty-free music, you'll find a whole host of different host sites where you can pay a subscription and use that. And
Good. That's good information for our viewers and listeners. And remember on this trade secret, well, not so much trade secret, but trademarks and copyright protected works, get permission. You may have to pay a royalty fee of some sort, but believe me that a royalty or more particularly, it would be called a licensing fee. That's going to be a lot cheaper to you than getting involved in legal fees with a lawsuit. It happens more and more, Rick. But social media sites and blogging sites and chat rooms, especially, you start having issues with defamation of character. And defamation, of course, is a tort. And if you defame someone's character and you publish it to a third party, that third party, whether the third party personally thinks it's an insult or not, that is the criteria upon which you can bring a lawsuit against somebody for defamation. Mm-hmm. Now remember, folks, in these shows we're trying to give you the basics. We're not going to go into defining every legal term that we mention. You can certainly follow up with me on that if you have an interest in getting more involved. But defamation of character is where you, generally speaking, you make a comment that affects a person in his everyday life, his reputation, or his ability to do business. And if someone looks at that comment and it's that person is a third party, that means neither you nor the person you're speaking about, that can be grounds to bring a defamation action. You've got to be really careful on social media sites today because you're liable. You're loved to get out there and say that no good.
Yeah.
And some of these reviews on Yelp and stuff, you could probably speak to that. There are all kinds of
well, it's so easy these days because we're so into instant gratification or instant interaction that it's very easy for us to state our opinion.
Sure.
And that's where you really have to be careful, because if just one slip of the tongue or one slip of the keyboard, can get you in a lot of trouble. And even if you think you're doing this anonymously, there's still ways to track that to you. Via I think via an IP address possibly, and so.
So you got to be very, very conscious of that. My thing, folks, has always been take the high road. It's very rare that you're going to go through whatever career you have that somebody's not going to be dissatisfied somewhere down the line. The old adage, you can't please everybody all the time, right? But that doesn't mean that somebody who's dissatisfied has to reduce it to writing on the internet. If someone does, you take the appropriate action to get it off the internet. You don't address it by trying to get back at the person in some way, shape, or form. Take the high road. Don't reduce yourself to their level, and set yourself up for a lawsuit. We also want to remind our viewers and our listeners, Rick, that electronic discovery in lawsuits, if you get involved in the lawsuits nowadays, is really prevalent. So courts can look to these social media sites and what's written on them and use that as evidence in a trial against you. So you have to be very cautious of these things. Remember, being a nice guy and getting permission where necessary is taking the high road. Don't take the low road.
Right. And if you have to take the low road, do it personally or
right.
privately.
Right.
Now, don't put it on the open web like that.
Well, I wanted to take our first commercial break at this juncture, and I'd like to have Rick tell us specifically about the video marketing he can provide you as part of his marketing package at R2 Visual Studios.
Yeah, thank you, Bill. Yeah, we specialize in a lot of things visual, whether it's headshots or commercial photography. We also do the consumer side too, like the weddings and the personal family photos. But one of the biggest things, or the most popular things we're asked to do, is the video marketing side. We have a lot of experience on the video marketing side and video production side. So we help people from scripting to the end product and delivery and platform placement and those sorts of things that they may not consider or know how to do. So whether it's something to promote a personal brand or something to promote a business in the form of about this is about us type of video, or why would you hire me type of video, there's different techniques that we use to help promote whatever specific need there is in a video production. So if you want to learn a little bit more about what we do or how we do it, you can go to our website at r2visualstudios.com. Our commercial real estate side, where we do a lot of production there, is r2realestatemedia.com, or you can contact me directly at rick@r2visualstudios.com, or on via phone at 310-567-7918.
Fantastic. And you know what I think Rick doesn't speak to enough, frankly, and I think he's just so wonderful at, is being able to utilize videos on a number of different sites to give you proper SEO and great analytics, and also to use video emailing. All of these things that Rick does can be used in the true marketing sense to promote your business. Once he takes your video, it doesn't stop there. He can then show you ways to make that video profitable in and of itself. And when that video is profitable, your business is profitable.
Right.
So look up Rick if you need some great marketing techniques. I know you won't be sorry. Well, let's get back to our show. And on the second half of the show, I wanted to speak to some human resource issues. Basically, it's becoming increasingly important and more prevalent where human resource departments of companies are looking to Facebook and social media sites, LinkedIn, that sort of thing, to decide whether they have proper job candidates. Mm-hmm. I mean, I know even some people some businesses that are using Craigslist. I wouldn't do that personally for a number of reasons, but there are certain media sites that you can go to and look at somebody and say, hey, I wonder if this guy would be worth interviewing. In other words, should we bring him in for the first step? Should we invite him in for an interview? And while that's becoming more prevalent, you need to make sure that your hiring policies do not violate any laws against discrimination. Okay, you need to look at a broad spectrum of people if you're going to do this. If you're going to bring people in to interview off the social media sites, don't create a policy and practice where you only bring in certain groups, certain ethnicities, or certain sexes, male or female, that sort of thing. You want to bring in a broad spectrum. It's similar to, the policy that pro football has, where you must interview a certain amount of candidates, and certain, principally I think it's more black and white. You have to interview people over a broader spectrum of ethnicity and background than you do in some of the other businesses that I can think of off the top of my head. But they have to be able to say that they have an anti-discrimination policy. Well, while they're not using social media for that, my point is, if you are using social media as a company, those are some things you have to be aware of, Rick.
Yeah, I mean, it just sounds like to me, just common sense that the same rules apply, whether you're doing it the conventional way or using, enhancing your reach with social media.
Right. And we even have issues involving dynamic sites like Wikipedia, and I wrote this down because it's hard for me to pronounce. Wikipedia apparently has a flagged revision program for entries about living people, and these need to be approved before they're posted. Companies need to be aware, in general, that before things are posted, they should have approval from your supervisor, even if there's a policy in place in your handbook. You better go get approval and backup to make sure that these things are approved. Now, these dynamic sites like Wikipedia can run into all kinds of problems, Rick.
Yeah, I can imagine. I mean, I know for a fact that you and I know people in the financial industry that are really almost forbidden to being on social media like Facebook and that sort of thing, at risk of saying something that may violate company policy. And I know one company in particular is now allowing some interaction on LinkedIn, but there are canned responses that they have to dish out when somebody asks, could be a friend, asks them a general question.
Yes.
There's a canned response for that. It's like response number 19. Here it is.
Yeah. And that's a good point. But in general, as we talk about these things, I think that the two principal things that I think about right away or advice to people would be, number one, if you're not sure about it, ask.
Yeah.
Okay? If you're in a company situation, ask your supervisor. And if you're on your own and you're on a social media site and you might find it insulting, then just assume the other person would. Okay? And don't write about it.
Yeah.
Again, take the high road. Mm-hmm. Following up on our human resources issue, remember that you can also start posting recommendations now to people, about people. And this can have an unusual effect. If you post a good recommendation about an employee, for example, that could make it more difficult to terminate him in the future, and if he becomes a problem. Or a negative recommendation may be discriminatory in content, it may be defamatory in content, it can run into problems as well. So I would urge people to keep employee comments to a non-existent minimum, and just keep the drop file on employees that we spoke about in an earlier show, where if the employee's good or he's doing bad, you put it in a little drop file. That drop file is pulled out at the end of the year, and that becomes your annual review.
Yeah, especially, I could see where that could be a problem, especially if you're talking about a subordinate, right?
Sure.
I didn't realize though that you made a good point. I never even thought about where you make a positive comment about somebody that could bite you later on.
Yeah. Well, why supervisors would be online doing this? They would never in the world that existed prior to the World Wide Web. Mm-hmm. But they're so engrossed into participation that they lose sight of their job as a supervisor. Mm-hmm. And they're becoming, they're overlapping into the normal guy who just wants to participate in this everyday chat world, Right. And you got to be careful of that. Mm-hmm. Now I want to talk about securities for a time being. Let me recap here real briefly, because we are talking about 10, what we think would be 10 essential categories. One was disclosure of confidential information. Next was trademarks, then copyright. Fourth was defamation. 5 was electronic discovery by the courts. We talked a little bit about the release of dynamic information, and number 7 was human resource issues. The 8th one is securities, and this follows up on a comment you made earlier, Rick. The CEO of Whole Foods was taken to task by the Security and Exchange Commission, the SEC, when he made under a pseudonym. He chose a pseudonym, and then he made derogatory comments, if you will, about his competitor called Wild Oats. Well, of course, he eventually bought Wild Oats. Whole Foods did. And after this acquisition of Whole Oats, the SEC investigated in anticipation of trying to find out information that would show that his prior postings under the pseudonym were an attempt to disparage the company and drive the price down for purchase. Sure. So now I know that's not going to happen every day with all of our listeners and viewers, but it just emphasizes the fact that you don't want to get involved with the SEC, number one, and number two, more specifically, don't take the low road. I can't emphasize that enough. It's just not worth the risk, folks. It's not worth the hassles that you could run into.
Take it from an attorney.
Yes.
Take the high road, folks.
Take it from anybody, but take it from a lawyer. Yeah. If that's what you need, take it from an attorney. Yeah. The ninth topic I wanted to speak to would be privacy issues. Companies in certain industries, healthcare industries, you have to be careful that you're not violating public policy and privacy issues. We all know with HIPAA today, the privacy, healthcare privacy is important. You can't be tweeting about a patient's condition. You can't be speaking in a derogatory fashion about someone's illness, or that you hope he goes to hell, and all that kind of good stuff. You can't do those sorts of things. So you have to be really careful about privacy issues. It's another social media awareness tip. And I did locate and wrote down a case where a woman sued 2 debt collection agencies for violations of the Fair Debt Collection Act after the collection agencies posted information to her MySpace page about her debts. Now that's an unbelievable example, and it's to the extreme. Mm-hmm. But you got to be aware of who runs collection agencies. Not always the brightest bulbs in the socket, and they're not necessarily trained legally. In fact, most often they're not. And that's why I have a letter that I put together for my clients who ever run into debt issues, where you make these debt companies aware that there is a dispute with regard to the debt, if there is indeed one, and by law they have to immediately cease and desist in trying to collect monies from you until the dispute is resolved. So you need to be aware of that, but more particularly you need to be aware that you need to make them aware that any kind of information on the internet, whether there's a dispute or not, could lead to a lawsuit by you against them.
Would you recommend that if something like this happened to an individual, that the individual reach out to the disparaging company, or would you get representation to do that for you?
No, I would have no problem advising them to reach out individually and making them aware of it right off the bat, mm-hmm. and then making a notation of the date and time they spoke to them and who they spoke to, and then sending them off an email saying that this is a disputed issue, this debt is a disputed issue, assuming it is, and that by law you are politely encouraged not to cease and desist with any future letters or phone calls to me, and of course that would include any internet postings. And if you want to handle it legally, it's not that big of an expense to have it done by a lawyer, candidly, at least not by me. But you should be aware of those things. And then the 10th and final issue that we wanted to talk about, Rick, was endorsements, and by the FTC. The FTC, the Federal Trade Commission, of course, has issued new rules even recently about bloggers and social media people, whereby they have to disclose, in fact, that they are being paid to make endorsements. So if you're endorsing somebody and you're being paid for these endorsements and you're not disclosing that, you need to disclose it. That would be the first thing I would tell you, mm-hmm. because the FTC's primary goal is to make sure companies are kept in line. And just because you're not technically a company, if you're endorsing someone, make sure you say that if you're paid, you're being paid for the endorsement. Mm-hmm. If not, we endorse people on the show. We do commercials for people on the show, and we're not paid, so we don't say anything. But if we were being paid, I think it would be our obligation to make sure that one of our paid endorsers is so and so and so forth and so on, and we're here to make everybody aware of that fact. So,
Well, I can speak from personal experience and just my dealings with internet marketers, right, that are selling specifically, it's mostly software products or services, subscription services, and that another way for them to reach a larger audience is to gather affiliates, right? And through that partnership of an affiliate, they reach a larger audience because basically they're marketing to their list. But at the same time, the compensation to an affiliate may be anywhere from 10 to 50% of the sale of the product, right? And so I know at least the ones that I deal with make that clear up front that they're representing this product, and then they also receive a commission based on the sale of that product. So it's fully disclosed.
Right, and while that may be more generally understood in the everyday business world, our point here, folks, is to make sure that you're aware that when you're on the internet, many things now, as you've seen from our discussion, are similar to and parallel to what happens off the internet when it comes to business. And so you need to be aware of those things and be cautioned of those things so you act accordingly on the internet. Because now that this information can be dispersed so widely in such a short period of time, now that opens up the floodgates, right, to any potential problems that you may experience if you don't do what you're supposed to do.
Yeah, exactly.
So that's critically important. So I just want to sum up by saying social media or social networking always provides you the greatest of tools in the everyday business world today, Rick, and I know that you're certainly one that can speak to that with what you do. But with those great tools come risks. You need to be aware of the legal risks and the overlapping legal issues that are involved in social media today and media marketing and things of that nature. Be aware of it. Be clear. If you're not, ask somebody, principally a lawyer, who can answer your questions for you so that you move forward in the right direction without being involved later on. Remember, if you're unsure, ask, because as I have always said, you don't have to be in the wrong to be sued, right?
Right. I mean, just use your common sense out there, folks. The same things that apply offline apply even more so online.
Please, I would echo that. Use your common sense. Before we get into what's on next week's show, I wanted to insert a brief commercial for Strider watches. We've talked about Strider watches over the course of several shows. They're owned and operated by a friend of mine named Jim Skelton, and you can go to his website and just Google Strider watches. You'll find a whole array of stuff on the great watch that he provides. It's called a Hyperdive. Great quality watch. It's a timepiece of exquisite quality and aesthetic appearance, and it also allows you to wear a really what I term to be a great piece of jewelry on your wrist and be able to tell the time at the same time, so to speak. So check out Strider watches, owned and operated again by Jim Skelton. Jim can also be seen on World of Watches TV every Saturday and Sunday from 3 to 6 Pacific time, and also on channel 227 on DirecTV. And that leads us into next week's show. That will be, Rick.
What's on tap for
next week? That will be. We're going to discuss fictitious business names, or DBAs, doing business as, and some of the things that encompasses, and what our viewers and listeners need to be aware of. Because I think interestingly enough, whether you have a business entity or not, DBAs can come into play. So we're going to discuss fictitious business names next week's show, and we'll look forward to having you all join us for that.
Yeah, I'm looking forward to hearing about a little bit more about DBAs, because I think that's kind of a topic that people really don't understand all that well.
Certainly, I think some people take it for granted.
Yeah.
Well, I don't have to do anything I don't have to incorporate, or I don't have to have an LLC because I don't want one, or I don't think I need one, so I'll just operate under a DBA and I'm home free. Well, there's a little more to it than that.
Yeah, and we're going to all learn about it next week. So
We'll do that next week. We'll look forward to having you all with us. We hope you got something valuable out of today's show. I think it's important to know that what you do on the web today can have serious consequences if you don't do it right. So with that, Rick, I'll say goodbye and have a prosperous week to everyone. And I'll look forward to seeing you here next week.
absolutely. Well, thank you again, Bill. I had a great discussion with you here today. Enjoyed it, and we're looking forward to seeing everybody again next Tuesday at 10 a.m. Pacific time here on the Bottle Business Sense Show.
You got it. Take care, everybody.
Take care.